So, as I mentioned, this is the Life After F1 workshop. This is an annual workshop that we do here at Santa Clara in order to help our international students understand employment sponsorship generally, and then specifically the H-1B process. And so I'm going to go ahead and get started. I do have a lot to get through, but I'm hoping to leave time for questions, and I'll explain how I'd like you to submit questions in the coming slide. So, as I mentioned, we are doing a recording of this, and the slides and the recording will be available on our website, Life After F1 website, within usually a couple of days. In terms of what we're going to talk about, we're going to talk about just sort of generally work authorization and what happens after your F1 status ends if you want to stay in the US, and do you want to stay in the US? And then I'll go into kind of specific details about the H-1B process. All right, moving on to our presentation. So I think the first thing that we like to do here at Santa Clara is just talk a little bit about kind of how we contextualize H-1Bs. So I think a lot of people have questions and they come to us with questions about H-1Bs, but we like to contextualize this as life after F1, right? So when you're on F1, be it as an enrolled student or after graduation when you're on OPT or STEM OPT, you are still considered an international student, which means that your immigration status is sponsored by and tied to the university. And so we're really here to support you and assist you in maintaining your immigration status. At some point, that sponsorship ends, right? At some point, you complete your degree, you finish the OPT or STEM OPT that you're eligible for. And for some students, and actually I would say it throughout my life and career, I would say an increasing number of students, they are ready to go home at that point. Some students pursue additional education in the US, maybe get an advanced degree or perhaps another advanced degree. And then some students wish to continue to live in the US for a variety of reasons. Some people like where they're working. Some people have found an American that they want to build a relationship and a life with. And so we do know that there are some students who want to stay, but I also want to normalize the fact that not every international student stays in the US. Not every international student works after graduation in the US. Some people return to their home countries and live very happy, exciting, interesting lives. And I think there's a lot of pressure around this idea that you have to do OPT, you have to do STEM OPT, you have to get a work visa and stay in the US long-term or even permanently. And that's just not the case. But for students that do want to stay, there are a variety of options, right? So there are both immigrant and non-immigrant options. So the F1 student visa is a non-immigrant or a temporary visa. H-1B work visas are temporary. A lot of the work visas are non-immigrant, temporary, short-term. There's also permanent, specifically lawful permanent residence, which often is called green card applications. And there's tons of different options for these things, some of which are applicable to you and some of which are not applicable to you. But all of them require a primary and a dependent relationship. And typically the immigrant is in the dependent relationship. So it's going to require you to have a family relationship. It's going to require you to have an employment relationship or somebody to essentially sponsor you. And that's just how the US immigration system is set up. When we talk about H-1B, the reason so much focus is on H-1B is because in the non-immigrant class, in the shorter term classes, there aren't a lot of other options for short-term sponsorship. If you're a citizen of Canada, Mexico, Singapore, Chile, or Australia, you have alternative work visas available to you. There are some people, depending upon where they're born, specifically if you're not born in India or mainland China, you may work with your employer to opt to go straight for a green card, which again is that immigrant, that lawful permanent residence. That's kind of like a forever thing. And there are options for people who like start their own companies, people who have like a lot of money to invest, people that have extraordinary ability, which is, you know, people who have like Oscars and Emmys and Olympic gold medals. But for the majority of people, that just want to try to work in the US for a little longer than OPT and STEM OPT, the H-1B is the primary option. And so that's why we talk so much about H-1B. That's why you hear so much about H-1B, because there's not a lot of other options available to most international students that are making that transition off of student status. And so that's primarily what I'm going to be talking about tonight. You know, if you're in one of the unique situations, if you're one of the citizens of one of these countries that have special country visas, or, you know, if you are working with a company that wants to go ahead and pursue a green card for you immediately, that's great. And I'm not trying to downplay those options. It's just that that's not applicable to most students. All right, so I'm going to go into H-1B and what that is. So an H-1B is a non-immigrant work visa. So if you're new to Santa Clara, if you're early in your academic program, if you're, you know, a freshman or a sophomore or junior undergraduate student, if you just started your grad program this year, this is probably a little early for you. We do this workshop every year. H-1B stuff changes pretty frequently. And so we're really talking about stuff for people who are, you know, about to graduate or have graduated and are currently working using the F-1 work options of OPT and STEM OPT. This is kind of after OPT and after STEM OPT are exhausted. So as I mentioned in the previous slide, an H-1B is a non-immigrant work visa. It's a type of immigration status that allows you to be in the country working. The government agency that approves these applications, they're called petitions, is USCIS, the same government agency that's taking their sweet time approving OPT and STEM OPT applications. H-1Bs are really different than OPT or STEM OPT. OPT and STEM OPT is kind of blanket work authorization to train in your major field. H-1Bs are extremely employer specific. They're specific to the company, they're specific to the work location, they're specific to the job, specific to the salary, and they're sponsored by a company. The company is the petitioner, and the immigrant is considered the beneficiary of the application rather than the applicant. So when you're applying for F-1 benefits like OPT and STEM OPT, you're the applicant. That immigration benefit belongs to you. But in the case of work visas, the immigration benefit kind of belongs to the company, and you're just along for the ride to some extent. And I'll talk about what that means in a little bit here. H-1Bs are for specialty occupations. And so this is an occupation or a type of job that requires a bachelor's degree or higher in a specific major. So the example that I like to give is you could not get an H-1B to be a barista, right? A fancy coffee maker. That is not possible, because not only does that job not require a bachelor's degree in order to do it, but it doesn't require a bachelor's degree in a specific field, right? Even if your local Starbucks insists that they will only hire people that have a master's degree to be baristas at their Starbucks, you still couldn't get an H-1B for that, because the job itself doesn't have the specialization required to mandate that you have a bachelor's degree. Another example that I would give is some of the more general business occupations, like being in human resources, can be challenging for H-1Bs. And the reason is that even though the job itself is highly advanced and specific, and you need to know a lot of information, my job is like this, right? I have to have a lot of expertise. But here's the thing, I would have a hard time getting an H-1B because my job does not require me to major in a specific field. Within our office, we have people that have philosophy and women's and gender studies majors. That's me. We have people that have poli-sci majors, people that have majors in foreign languages, international business, and we all do the same job, right? And so that would be a hard time in terms of specialty occupation, because it's not in a specific field that the degree is required in. Additionally, H-1Bs require the company to pay what's called a prevailing wage, right? And so the government helps the company look at the field and the occupation of the job. And it says, based on the field that the job is in, based on the location where the person is working, here is a normal wage or a prevailing wage for that position. And the company has to promise to pay that wage. The most common H-1B filings by far are the tech sector. You also see a lot of H-1Bs that are filed in the finance sector, some in the medical field, but tech and technical business are probably the most common types of H-1Bs. Last year, the government started a special sort of like extra advanced filing system, and I'll talk about that. And H-1Bs cost money, a lot of money, in fact, quite a bit of money. And so this is like a pretty extensive process, right? It's not something that you just wake up in the morning and you're like, I'm going to get an H-1B today. In terms of H-1Bs, what's really important, and this is why they get so much attention and so much conversation, is the fact that there is a limitation on the number of new H-1Bs the government is allowed to give out every year. And because of this limitation, there is essentially a very arbitrary lottery process. And so some of the things that you might hear when we talk about H-1Bs, you might talk about H-1B cap. You might hear people talk about the quota, the lottery. And what they're talking about is because the US Congress for more than a decade has limited the number of new H-1Bs every year, and there's more people that want H-1Bs, or companies file more petitions than there are spots available, what the USCIS has to do is they have to do a random lottery to figure out who gets those slots. So last year, there were 275,000 petitions, 275,000 registrations submitted for about 85,000 spots, right? And so it is a very problematic situation. And this is why so much pressure is put on the H-1B, because you could have an H-1B filed on your behalf this year and just not get picked in the lottery. It happens. It absolutely happens. And sometimes it happens to people multiple years in a row. And so because of that, it's very high stakes, and companies spend a lot of time and money thinking about it, and employees, that pressure kind of trickles down, I would say, not only in your work environment, but in your social groups. And I'm sure that you've heard from, friends about this H-1B, right? And so the way that they distribute that 85,000 is they do set aside a special section of it, 20,000 of them are just for people that have US master's degrees or higher. And so there's like extra likelihood of being selected if you have a US master's degree or a doctoral degree. So that's kind of a little bit about H-1Bs numerically. I like visualizations a little bit. So you can see over the past, 15 years or so, it's the numbers of H-1Bs that are filed, they have historically kind of gone up over time. You can see during the recession in 2007 and then a little bit in the early 2010s that there was kind of a dip in the filing. We're still talking about, 100,000 cases, 75,000 cases, 85,000 cases being filed, but, nothing like last year, which was, a record year in terms of, 275,000 registrations for the lottery. So a very, very big deal, and certainly something that I think is like a well-known problem. So I think there's a lot of questions about how the lottery works, and I want to kind of talk about historically how it worked, and then I'll talk about what the current process is, and then there's some proposals that aren't going to go into effect but are making people nervous. So in terms of how the process used to work, it used to be that the first day you could file is April 1st, and that's because the fiscal year for USCIS starts on October 1st. The regulations say you can file 6 months early. April 1st is the first day to file. And so it used to be that like literally on April 1st, 100,000 applications, 200,000 applications would show up at the USCIS office. And they literally would have to like open every package, process everything in order to get this lottery done. It was extremely time consuming, extremely stressful. Back before I worked at Santa Clara, I was an immigration paralegal for 7 years, and I spent 7 years preparing H-1B applications. And this time of year would just basically be like nonstop, just paperwork, just getting things ready to be filed. That's not how it is anymore. Starting last year, they have now initiated what's called a pre-registration or a registration process. And the way that it works is instead of preparing these hundreds and hundreds of pages of applications and mailing them to the government and waiting for the government to do the lottery and then having the government mail them back to people, wasting all that money with mail going back and forth, what your company or their attorneys do now is they actually do an electronic registration, and the lottery is based on the electronic registration. There was a proposal that the lottery not be random, that instead of being a random lottery, that it be ranked based on higher wages. The higher the wage, the more likely the H-1B would be to be selected in the lottery. That is not going to be put into place for 2021. It may or may not be put into place for next year, but it is not happening this year for sure. That has been announced. In terms of the pre-registration process, the pre-registration happens soon. There's like a period of time where the attorney or the company go into the system and they create these registrations that are based on, the company's information and then your information, your name, your bio data, your educational background. And the employer pays a nominal fee, $10, and then the registration, is submitted. They will, if they get more than the minimum number of cases, so if they get, more than 85,000 or more than 20,000 master's candidates apply, which, inevitably that will happen, they'll do a lottery. They do the master's lottery first, and then they do the regular lottery. And then if your case is selected, the company and their attorney will be notified, and the notification happens via email and also within the registration system. You will not be notified. You will only be notified if your company or your company's attorney see fit to notify you. And then once the notifications go out, the company can actually submit the real filing. The real filing is like the checks, the government forms, copies of your diplomas, copies of your transcripts, your passport, the company's financial statements, all of the stuff that goes with the application. And then what we saw last year is because not every single person whose registration was selected ended up actually filing a petition, they were able to do a second lottery to use up the unused spots. So it's like, if a company submits a registration on behalf of an employee and that registration is selected, but the employee ends up leaving the company, that goes back into the pool to be used in a second or a third round of selection. So we did see a second round of selections last year, I believe in May, which was good because it means they're actually using the H-1B quota fully. So at this point in the year, this process has already started. Attorneys have already started working. My friends that are paralegals at law firms are already filling out forms, for people already prepping the registration. They can't actually get into the system until March 9th, but they're already collecting information from beneficiaries. And so if you are interested in this, you should definitely be in communication with your employer about it. Okay, so we get a lot of questions. Anybody that works in this field gets a lot of questions about odds. What is the odds that my H-1B will be selected in this lottery? And I think one of the problems is data. And the reason that there's a data problem is you can't really calculate the odds unless you know exactly how many of the cases were masters versus regular lottery. And unfortunately, the government doesn't release that information. We ask them for it every year. We say, please, can you tell us what number was masters and what number was regular? And they just don't tell us. The last time they told us was based on April of 2018. And so my spouse, who's a little bit of he's a math head, he's really into math, did some calculations with me. I'll flip over to the next page. He did some scratch notes with me based on the last time they gave us numbers, what was the likelihood of, your case being selected if you had a master's degree versus if you didn't have a master's degree. And they did change the method. I think on the last slide, I said that they did the master's lottery first and then the regular lottery. That changed in 2019. Now they do the regular lottery, which is every single application. And then they pull out anybody that was not selected that has a master's degree and do that special master's only lottery. Based on the 2018 numbers, that would have given, a 4-ish% increase in likelihood of being selected with a US master's degree. And these are 2018 numbers, which was less filings than 2020 last year. And so I would expect that the likelihood of being selected, is less than 50%, but we don't have the numbers to know what percentage of the filings were masters. They said about 275,000 cases were filed and about 46% of them were US masters candidates last year. So just a little bit of dork stuff there. So the registration process happens online. This year, the timeline for that is between March 9th and March 25th. Between March 25th and March 31st, they're going to actually be doing the physical lottery, which is like they have to run the numbers, right? And then by March 31st, they will notify the attorney that filed the case or the company, if the company did their own registration, that the case was selected or not selected. Once your attorney or the company is notified, they have to prepare and submit via mail the actual filing. And that's, again, where the checks and the forms and all of the supporting documents come in. Those who have done OPT and STEM OPT have a little bit of an idea of how annoying that process can be. And then once the filing is delivered to USCIS, it gets receipted. And that is the point at which the information about the H-1B would be going into your SCIVIS record. So up until the point that the case is receipted, we cannot see anything in your SCIVIS record. We can't tell if a registration was filed. We can't tell if the registration was selected. We can't tell if the application was filed until it's receipted. And then, as with the registration, the receipt goes to the attorney or the company, and hopefully they're proactive and notify you about it. And then once the case is receipted, it basically gets assigned to an officer, and that is called adjudication, where they actually review the bona fides. That's when they're looking at the wages and they're looking at the occupation and they're looking at, do you really need a bachelor's degree in philosophy to be, barista at Starbucks? And that's what they're looking at, is that the details of the position and the company. And then they take action on the case. The action could be approving the case. The action could be denying the case, and the action could be issuing a request for evidence, also called an RFE, where they ask for additional information. And this process can take a while, right? So the actual filing is going to start in April, and they get, a filing window. This receipting will continue to happen, I would say, throughout May. Adjudication happens usually May, June, July. Frankly, sometimes it drags on into August. I've seen cases that, are still pending in September, October, November, especially cases that get requests for evidence. It usually takes the company and their attorneys time to prepare the evidence and submit it, and then it has to be, back into the adjudication pool. And then, hopefully your case is approved. And if the case is approved, it will either go into effect immediately if it's filed as a change of status, or if the case is filed under consular processing, you would have to leave the country, get a H-1B visa stamp, and come back into the country before the H-1B goes into effect. So there's kind of two types of H-1Bs that are filed. One is change of status and one is consular. I'll talk about that in a slide or two. As I mentioned, the timeline doesn't always work out. Usually at the beginning of this process, USCIS will suspend premium processing so the company can't pay extra money to get a quick answer. At some point in the process, they sometimes resume it, but it's usually late, August, September, October. Like I said, requests for evidence are more and more and more common. At one point, the RFE rate was over 1/3 of cases were getting RFEs. The review time, the adjudication times have slowed considerably in the past few years. When I was working in the field and I was filing H-1Bs on behalf of companies, it was extremely rare that H-1Bs would be still pending in August. And I would say it's very common now for H-1Bs to be pending. It used to be that if it was still pending in August, something was really wrong. And now it's like super normal for that to happen. So it can be, slow, and the denial rates are high. And I think, there's always proposed regulation changes, proposed revisions. Right now, all of the proposed regulations are on hold based on an executive order that the new president put out, just basically saying we need to get our feet under us. We're not going to move forward with any changes that were proposed by the last presidential administration. But there are always things going on. So, one of the things that has happened in the past few weeks is a bunch of ways that they review cases. A bunch of the guidance that they've been putting out over the past few years has been rescinded. And so these officers that are reviewing the cases, they have to update themselves, right? Because they used to be skeptical of third-party placements. They used to be skeptical of the utilization of, a special occupational code for computer programmers versus software engineers. All of that's been rescinded, right? And so not only are attorneys considering this as they're preparing applications, but it's, when these regulations are changing so quickly, the people that actually review the applications need to retool themselves, and they need to, reorient how they review applications. And so it'll be interesting to see this year if the RFE and denial and delay rate is as high as it has been in the past few years. So I think that, one of the things that we want to point out, like I said, is, you don't necessarily have to have an H-1B, like we have had many successful, talented students that have done a year of OPT and returned to their home country, have done a year of OPT and 2 years of STEM OPT and returned to their home country, or moved to a different country, move to Singapore or Canada or the UK. You don't have to stay in the US. And I want to say that out loud because I think that people don't hear it enough. And so as much as I would love for everyone to get exactly what they want, I also want to make it clear that choosing to return to your home country or choosing to move to a different country is not a failure in any way. I don't think people say that enough. I feel like so much pressure is put on H-1B and is your company filing or not, that people don't feel like they have agency to say, I don't need an H-1B. I'm not planning to stay in the US for the next, 3 to 6 years. So I think it's really important that you decide whether it's worth it for you, and know that you can tell your company no if you don't want to do it. And that's okay. I think that, some people choose not to have H-1Bs filed on their behalf because they're changing employers and they don't want their current company to spend a bunch of money on an H-1B that they're never going to use because they know that they're leaving, because they're planning to leave the US. So it's important to kind of know that there are options. One of the options that we like to talk to students about is having your H-1B filed under what's called consular processing. And this is becoming more and more popular, but it often involves a conversation with your company and their attorneys. I'm going to put up a slide that has a lot of really dense information about this. I'll talk about it kind of generally. Remember, I'm going to put the slides on our website, and we have some information on our website about consular processing versus change of status. So most H-1Bs are filed using the change of status option. And what a change of status does is it asks the government to literally change your immigration status from, in this case, F-1 student to H-1B worker. And the idea is that once the H-1B is approved, on the day that it goes into effect, that would be October 1st, your immigration status is like, poof, changed, right? You're no longer F-1, your CVIS record gets closed, and you are now an H-1B worker. That sounds really great, but there are some negative things about that. Specifically, change of status means that you're giving up any remaining OPT or STEM OPT time that you have left. So if you're in your first year of STEM OPT, you have a whole other year of STEM OPT. There are tax benefits to staying on OPT and STEM OPT. There are employment benefits, specifically that OPT and STEM OPT are not tied to your employer. So if something happens, if your company goes out of business, if you get laid off, if you get fired, if you decide you don't like your company and you want to go to another company, You can easily do that on OPT and STEM OPT. You cannot easily do that on H-1B, right? So agreeing to have a change of status filed on your behalf is making a big commitment. Usually when I do this workshop in person, I play the Beyonce song Single Ladies. If you like it, then you should put a ring on it. That's my singing. And the joke is an H-1B change of status is like getting married to this company. It's not to say that you can't leave the company. It's just to say that if you want to leave the company, you're going to have to get the lawyers involved because you're going to have to go join some other company instead, right? It's like getting a divorce almost. And so if you like the company and you want to commit to them, a change of status might make sense. But if you're just not sure, there is an alternative. There is an alternative. And the alternative is called consular processing. And literally, this is a checkbox on the I-129, the H-1B petition that the attorney checks, that instead of changing your immigration status on October 1st, what this does is it notifies a consulate in your home country that an H-1B has been approved on your behalf. And when you're ready, when you and the company are ready, you can leave the country, get an H-1B visa stamp in your passport, and come back into the country, and then you're in H-1B status. The benefit of consular processing is that you are in control, in collaboration with your company, of course, on when your OPT ends or your STEM OPT ends. You can stay in OPT or STEM OPT work authorization. You can travel internationally while the H-1B application is pending, which you cannot do under change of status. And you can maintain your F-1 status, which is your status that belongs to you instead of the company. Now, there are some downsides to consular processing. I don't recommend it if you're in your last year of practical training. So if you are in your last year of OPT and not eligible for STEM OPT, or if you're in your last year of STEM OPT and not eligible for further extension, consular processing would not be a good option for you. But it can be a good option for some students. We like to bring it up because it's, we want you to be informed about what your options are. I would say that this is becoming more common, but it's not the prevailing practice. So most attorneys, without discussion, will just file the H-1B as change of status. They won't ask you what you prefer. They won't ask the company what they prefer. They just file it as change of status. If you don't want it filed as change of status, you would need to talk to your company about that. And the only note that I will make is that some companies, not all companies, but some companies see that as a lack of commitment to the company, right? Because the change of status is like getting married. Consular processing is like, it's like dating monogamously, but it's not contractual obligation the way that marriage is. And so you just have to, if you want to broach it, you have to broach it delicately, the same way that you would broach a raise or a promotion. It's something that you would want to, consider carefully and talk, intentionally to your employer about. So we also get a lot of questions about cap gap and STEM OPT. So this is principally for students that are on STEM OPT. This is another one of those really text-dense slides. Again, the slides and the recording will be shared to our H-1B website in the next day or so. We would recommend that even if your H-1B is filed, even if the pre-registration is selected in the lottery and the company files the H-1B, you should file a STEM extension. And the reason is that there is an extremely high rate of denial on H-1Bs. There's an extremely high rate of delay on H-1Bs, and H-1Bs are tied to the company. So if the company goes out of business, if you don't want to work there anymore, if the company doesn't want you to work there anymore, your H-1B and the inherent cap gap work authorization that comes with it, which is an extension of your OPT from the day that it expires until October 1st, when the H-1B would go into effect. That's what cap gap is. That goes away. And so I would say, by and large, if you are eligible to file a STEM extension, you ought to file a STEM extension. It is our very, very, very strong recommendation. The only exception that we would say to that very, very, very strong recommendation is if the H-1B is not just selected in the lottery, not just filed with the government, but approved, and you know for sure that your company is not going out of business, that you are not going to want to change employers, you could not file a STEM extension and instead use CapGap. But again, we really don't recommend it. We really strongly recommend filing STEM OPT. And I'm happy to talk a little bit more about that if it would be helpful. So just kind of to wrap things up, and then I'm happy to start with the questions. In terms of H-1B, you have some things that we want you to kind of keep in mind. So the first thing is, if an H-1B is being filed on your behalf, you should not leave the US without talking to, I would say, everybody responsible. So typically you just contact us if you're planning to leave the US, but in this case, you would not only contact us, but you would really need to talk to the attorney filing the H-1B. The other thing I want to mention is that your company is required to provide you documentation about the H-1B that they filed. Specifically, they're required to provide you information about, it's called a LCA or a labor condition application, that has information about the wage, the location, your job title, the occupational classification, and leveling. And so it should not be a totally challenging process to follow. Your company should be engaging you. Their attorney should be sending you documentation. You may not be reviewing every single thing that gets filed with the government because you're not the applicant, and so you're not signing the form, but they are required to give you some documentation so that you can know what's going on. You are not allowed to pay all of the filing fees for your H-1B. So H-1Bs have, I think, 4 or 5 different filing fees, depending upon if they do premium processing or if you have dependents. And several of those fees you are not allowed to pay. The company must pay them. I would say, in my experience, the common practice is that the company will pay the legal fees to the attorney as well as the filing fees. And typically you would only pay potentially if you have any dependent spouses or children that need H-4, which is the H-1B dependent immigration status. So if you have like a spouse that needs an H-4, then maybe you would pay for that. But typically the company's paying for everything. If the company's asking you to pay, to me, that's a red flag. I would say that's a red flag. Just a reminder that your passport and your I-94 or the I-797 approval notice, the bottom portion of that belongs to you. That does not belong to the company. They may not hold your passport. They can't withhold an approval notice from you. They are required to give it to you. Most companies are proactive about this, but I have occasionally heard of students having bad experiences. We also want you to know that as you're interacting with your company's immigration attorneys, it is really important for you to understand that they do not represent you. They represent your company. And so what this means is if, a company, an immigration law firm contacts you and asks you to fill out a survey and asks you to provide immigration documents and upload it to their, secure upload, that's great. Go ahead and do that, but don't seek out personal immigration advice from those people. For example, if you're planning on leaving your company and you tell the immigration attorney that filed the H-1B, they have an obligation to tell your company that you're planning to leave. So that's something that you would want to talk to your own immigration attorney about, not the company's immigration attorney. And it's really important to understand that just from a privacy standpoint. And then I think the most important thing that I don't think it's stated often enough is because the H-1B is a work visa and is tied to your company, it requires you to continue to be employed with that company, in that job, being paid that salary and working at a specific location. If any of that stuff changes, if you get laid off, if you want to change companies, if you want to move to the Dallas office instead of the Sunnyvale office, all of that requires additional interaction with the government. It requires the company to file an amendment. It requires a new company to file a change of employer. If you get laid off, there is no like grace period. You really need to find another job immediately or depart the US immediately. And so it's really important to understand that unlike F-1, where there's an unemployment period for OPT and STEM OPT, where you can change companies quite easily and you literally just have to tell us that you changed the company, H-1B is not like that. You know, it's very employer specific, and you're really, really making a commitment to be with that company. And so that's kind of the main takeaway that I want people to get when they think about H-1Bs is, you know, I want them to think about it as a lasting relationship with a company where they're making commitments to you and you're making commitments to them. So I think that is the extent of my kind of formal presentation. I've tried to keep it brief so that I have a few minutes to answer questions. I'm going to do a couple of things. So I'm going to go ahead and stop the recording so that I can focus on questions and answers. Actually, I'm going to keep the recording going just in case there's any really good questions that I want us to have the answer recorded to. But I am going to stop sharing this presentation screen. And I'm going to move the Mentimeter questions over. Can everybody see the Mentimeter questions on the slide? Okay, great. So I'm just going to start going through kind of as many questions as I can. We have about 15 minutes left, and I will, probably stick around for a few more minutes after that to try to help people as much as I can. So I'm on F-1 OPT with a valid EAD card. If my H-1B is approved as a change of status in July, can I travel internationally in August and enter on an F-1 visa before October 1st? It depends on how your attorney, how the attorney that files the H-1B on your behalf interprets things. Some attorneys think that it's okay to travel as long as the change of status is approved. So you can't travel while it's pending, but you can travel after it's approved. Some attorneys think that re-entering on the F-1 after the H-1B is approved, even though it hasn't gone into effect, would violate the change of status. And so every attorney interprets this differently. And this is why I would say, talk to the attorney that files the H-1B before you make any travel plans. And if you have travel that you need to do, if something's going on with your family and you know that you're going to need to travel between April and October, or really March and October, then you would need to tell the attorney, and that would be a good reason to have a consular processing H-1B filed on your behalf. Because if the H-1B is filed under consular processing, there is no restriction on travel. Okay, next question. What is the website to look up wages on percentile based on location? Oh my gosh, okay, I haven't done this in a really long time. But let me see if I can pull it up. So it's the OFLC online data center, and they have wage library. So you would do an FLC wage search wizard. Can you guys see can you see this page that I'm on? Okay, thank you. Just making sure. And let's say that you live in California, and we are in Santa Clara County. And then let's say that you're a barista. No, I'm just kidding. Let's say that you're a computer hardware engineer. So I just typed in computer hardware, and it brings up a bunch of different types of occupations, right? And if you click on the code, the occupational code, you can see some descriptive information about what differentiates this occupational code from other related occupational codes. And then let's see, view the wages for computer hardware engineers. Then you can see the wage leveling. So these are kind of the levels of wages. And so what the attorney does is they look at your position at the company and your background, and they determine the appropriate wage level for your position and your educational background. So that's kind of how wages are picked for H-1Bs. Back to the questions. And I'll just try to, I'm just realized I'll just put this in the chat. There you go. How does an H-1B application work alongside STEM OPT extension? What's the order in which we apply? They're really kind of like independent applications. They go to different service centers. They're filing different processes. They're on different forms. And I would say our recommendation is to file your STEM extension as early as possible, which means that you start the process 4 months before your OPT expires and you file the application 3 months before your OPT expires. The reason we recommend that you file as early as possible is they are taking forever to approve STEM extensions right now. And without the approved STEM extension, you might not be able to renew your driver's license. I think, you know, some people have had issues with that. And so we just recommend filing STEM as early as you possibly can. And it's okay if you file, like literally, even if it's filing like right next to each other, like you file, the company files the H-1B, you know, May 1st and you file your STEM extension May 1st, that's okay. That's a normal thing. It's totally expected. They do not interfere with one another in any way. Oh yeah, this question is so common and I like love and hate this question because it's really, you know, it's complex, right? Because it doesn't just have to do with what's legal, but it has to do with what's professional. So there are rules about having multiple companies file multiple H-1Bs. And the rules are that if the companies are related to each other in any way, common ownership, common address, if there's any possibility that the companies are related to one another, it is not allowed for both companies to file an H-1B for the same person. And so that would not be possible. But if it's two totally different companies, Google and Apple, it is possible to have multiple companies both file H-1Bs on your behalf. I would say that that is not a best practice. Now you have to decide what you think is right. There's nothing that would prohibit two companies from filing on your behalf. But number one, I see this backfire literally every year where company A files on your behalf and you don't want to join company A, and you have company B file on your behalf, and then company A's H-1B gets selected and it goes into your SEVIS record and it closes your SEVIS record because it goes into effect even though you never joined company A, you don't like company A, you never plan to work for company A. So I don't recommend it for that reason. And then the other reason I don't recommend it is straight up, these H-1Bs cost a lot of money. They cost several $1,000s in filing fees and several $1,000s in attorney fees. I would say, you know, an average of, you know, $3,000 to $5,000 depending upon the complexity and the attorney. And so it's really important that you understand the company is making a commitment to you. And I don't think that most companies would be stoked to know that their employees are like letting them spend thousands of dollars if they aren't actually planning to join that company. And I definitely know companies, particularly small companies, that feel like they've been burned by this before and refuse to file H-1Bs now. I think that's short-sighted, but I do know that it kind of puts a sour taste in people's mouths, which hurts other international students in the future. So again, there's what's allowed, and then there's, you know, what is the right thing to do, and you have to decide for yourself what the right thing to do is. Can I change my company after my H-1B approval? This is another it depends question. It depends on the attorney's interpretation. Some attorneys think that it's possible to file a change of employer using the approval, even if it hasn't gone into effect. So let's say your case is approved July 1st, you change companies August 1st. Some attorneys think it's possible to file a change of employer on August 1st, even though the H-1B doesn't go into effect until October 1st. Some companies or some attorneys think that you have to wait until the H-1B actually goes into effect to change employers. So this is not something that like every attorney would even agree about. But by and large, if you're planning to change companies, it doesn't necessarily require a new, like, let's say in a normal situation where it's like after October 1st, you're in H-1B status. It doesn't require you to go through the lottery again, but it does require the new company to file an H-1B on your behalf. The H-1B is called a change of employer. And so it does require the same amount of money and it does require the same preparation. It's just that you don't have to go through the competitive lottery process. You just, they just file the application. Yeah, so if I were to apply for both STEM OPT and H-1B and the H-1B gets picked in the lottery and filed and approved, what happens to the STEM extension application? The STEM extension application will go through its normal review process and it will be approved. You just will only use a few months of it. You'll just use it until October 1st when the H-1B goes into effect. Once the H-1B goes into effect, if it's filed as a change of status, your SCU record just automatically gets closed and the STEM OPT EAD card becomes invalid. Last year, the pre-registration fee being only $10 apparently resulted in a rise of duplicate cases, and this impacted the probabilities for international students. How will this be addressed? So I mean, I think that this goes, I think there's two things. So USCIS takes duplicative filings quite seriously. So like I said, if there is any relationship between the companies that are doing the filings, that are doing the multiple filings on behalf of beneficiaries, both filings will be revoked and the number will be put back into the pool for use. And this is quite serious and something that they definitely do. But I think that like the larger point here is that, you know, it used to take hours and hours of time to prepare the petition, a lot of money to FedEx the petition to the government, to create the filing fees in order to even be counted in the lottery. Now it just costs $10 and a little bit of advance work to be counted in the lottery, which is why you see the numbers go up so sharply. It was 218,000 in 2019, 275,000 in 2020. And so I do think this question is legitimate. There is a large number of, I would say, you know, a lot more cases being put into the registration process. I mean, I think realistically, what really needs to happen is the lottery numbers need to be increased. There's too few H-1Bs and too much demand. But that requires, you know, congressional will to engage in immigration reform for highly skilled workers. And if you're interested in that type of advocacy and you want to talk to your local congressional representatives who represent you, even though you aren't allowed to vote, let me know. And I'm happy to give you some talking points and connect you with your congressional representatives or some organizations that do that kind of advocacy. If I'm an H-1B holder and I want to change jobs, can my company deny my H-1B transfer? No, your company doesn't even necessarily know that the H-1B change of employer or the H-1B transfer, they're sometimes called, has been filed. So they have no say in whether you're allowed to change to a new company. The government has a say in it, but yeah, you are allowed to change without getting permission from your prior employer. Yeah, so if my STEM OPT case is pending or gets approved and I get an H-1B, do I need to notify ISS or do anything regarding STEM OPT? There is some STEM OPT like reporting obligations. So like when you end your STEM OPT employment, you are required to submit a final evaluation, which is on the last page of your I-983 training plan. So yes, usually if the H-1B is filed under consular processing, or excuse me, if the H-1B is filed as a change of status, where they change your status on October 1st, we typically know because a notation goes into your SCU record. And then on October 1st, your SCU record gets closed. The reporting of that was really messy last year because of the way that the multiple waves of the lottery happened. And so what I would say, and I hope Dustin's not watching this at home, is there's no harm in telling us that your H-1B went into effect. It just gives us a little reminder to like look at your record and see if it actually was closed. Most of the time we know, but like you can always send us an email if you're not sure. And that, I mean, there's no harm in it. If my H-1B, if my STEM OPT expires in July and my H-1B gets approved by October, will I need to go back until the approval? I'm not sure I understand this question. If you want to rephrase it and maybe shoot it to me in a private message, I can try to answer it, but I don't want to answer the question wrong. I'm just not understanding the wording of it. Can I travel outside of the US while my H-1B is under processing? If not, why? If you have an H-1B change of status that was filed on your behalf, so an H-1B petition that's pending with USCIS, you cannot leave the US typically. And the justification for that is that if you leave the US while a change of status is pending, the government thinks that you've abandoned the change of status application. We don't advise on how travel impacts the H-1B typically. Like I can talk kind of like vaguely and generally like I just did about it, but this is why we say if you have an H-1B pending, approved, whatever, and you want to leave the US, you need to talk to the attorney that filed the H-1B because they are the ones that can give you the best and most up-to-date guidance. I follow F-1 travel guidance really, really, really carefully because it's my job. I follow H-1B travel guidance kind of vaguely out of a personal interest, but I'm not like obsessively watching it. So, okay. Which H-1B option would I recommend? I would typically recommend, well, I mean, I think it really depends on your situation. I mean, I think that it depends on, I think it depends on how much you like your company, how likely you think you are to want to work for that company for the next several years, whether you've ever had trouble getting visa stamps before, if your company is a strong company that has a strong record of H-1B visa approval at consulates and embassies abroad. I don't think it's like a one size fits all answer. And so, yeah, I think it's a little bit more complex than just like, I would pick consular processing, or I would pick change of status. I think it just like really depends on your situation and the company's situation. And travel, right? Right now is not like the best time to travel, just because there's like a pandemic happening. How many years is an H-1B valid for? They're typically approved for 3 years at a time, and they can be approved for a total of 6 years. And then there's possibilities for additional extensions if you have a pending green card application. So usually 3 years is what the first one is approved for, and then they can do an extension for 3 more years and then potentially additional extensions. What options do I have if this is my last H-1B attempt before my STEM OPT expires in July? I would say you should have your H-1B filed under change of status. I will send good vibes to you and to the other students in this situation. It is a very challenging situation. And honestly, I'm going to straight up say it, unfair, totally unfair. And so I guess for me, it's just, I really hope that your H-1B is selected, you know, hold out hope, keep good vibes going. Like I said, they did 2 rounds of lottery last year. They did one in March and then another one in May because there were H-1Bs left over that hadn't been used in the first lottery. So, you know, hopefully good things will come your way. And then I would say, you know, I am sure that your company is already thinking about what will happen if the STEM OPT or if the H-1B is not selected. Your company may have kind of internal processes to handle this, but if you haven't already had a conversation with your manager and your company's immigration people about it, I think now is a good time to have that conversation about what will happen. Will you return to your home country? Will they transfer you to another location outside of the US? Will you go back to school? What are your options? Yeah. Will the pay scale affect my H-1B eligibility? This is a good question. And the reason that this is a good question is because of the fact that there was a proposal that H-1B wages would affect the lottery, right? That if you had a higher wage, you would get a higher chance of being selected in the lottery. That proposal is on pause. It will not be going into effect this year. So your pay will have no effect on whether your H-1B is picked in the lottery. But your pay is related to specialty occupation, and it is related to whether the H-1B is approvable. And so this is something, pay is something that USCIS pays a lot of attention to. And I would say when companies, choose to file H-1Bs for the very low, or like, for example, the level 1 wages, if you remember looking at that wage page, it is more likely that the case will receive a request for evidence, because sometimes USCIS will say, well, if this person is so low level that you're only paying them a level 1 wage, is this really even a specialty occupation? And then the attorney and the company will have to kind of push through and explain why it is a specialty occupation. So just to summarize, the pay does not increase or decrease your chances of being picked in the lottery. It doesn't affect your chances of being picked in the lottery, but it can impact the H-1B when it's under review with the government after it's picked in the lottery. Yeah. The e-transcript should work because it is an official transcript. But you can also request a printed copy. They usually arrive within a couple of days, and then take a scan of that. Okay, we are past time, so I'm going to go ahead and stop